Good afternoon and welcome. Thank you for coming in person, and those online, thank you for joining us. These days, you never know how many people will come, despite how many people register, so we're glad to see your faces. And want to let you know that after tonight's event, there will be a reception downstairs. So I hope you'll stay for that. So, as we all know, momentous civil rights decision by the U.S. Supreme Court. I was told the acronym people are using are SFFA versus Harvard University, Students for Fair Admissions is the term that was used. And that has far-reaching implications for higher education and how we admit students from various backgrounds to colleges and universities. So we thought we need to talk about this and figure out what comes next. And we've assembled a panel of experts, including one who's beaming in from Washington, D.C., because he's so busy we couldn't get him to come in person. But let me start by introducing Art Coleman, who is an attorney. Art, what's the name of your firm?
I don't think he can hear.
Okay, can't.
Education Council.
There we go.
Education Council, very generic term? No, just kidding. But thank you for joining us. Art also happens to teach on our faculty, and we're really pleased he's here. Next to him is Jerry Lucido. Jerry's also on our faculty. Jerry has been the director of CERP, the Center for Enrollment
Research, Policy, and Practice.
Research, Policy, and Practice, and we're glad you're here, Jerry. Julie Passault, who is also professor of higher education here at Rossier, and currently serving as the Associate Dean of the Graduate Division.
Graduate school. We're not
Graduate
in the UC
school.
system here.
Okay. Yes.
Yeah, that's UC.
The graduate school here at USC. And then finally, Kedra Ishop, who is the Vice President for Admissions and Enrollment.
Close.
Close?
The Vice President for Enrollment.
Oh, enrollment, not admissions?
I have a Dean of Admissions.
Okay. Who is also with us this evening. So each of these individuals brings a different take based on where they sit on what this means. And what we've asked them to do is to open up 5 minutes of remarks just on what they're seeing as far as the landscape of higher ed since decision has been rendered. And then I will, my name is Pedro Noguera. I'm the Dean of the Rossier School of Education. I will pose a few questions, and then we'll open it up to the audience as well as those online. So thank you for joining us. And there are more seats, so please.
Come on up.
No need to stand, although we like standing room only, but please take the seats and make yourself comfortable. So why don't we start with Kedra, and then we'll work our way down to
All right. Well, thank you. It's such a pleasure to see a full house. It's making it a little toasty in here, so make sure you take care of yourself if you need to grab water or anything. I am the VP for Enrollment here at USC. My prior role was a similar position at the University of Michigan, and prior to that at the University of Texas. And why that's relevant is that these three institutions have been at the center, along with Cal and UCLA, of a lot of these race-based decisions over just about the entirety of my career. So I started working at admissions about 25 years ago, almost to the day that the SFFA decision came down. So I took Friday off. I took Thursday and Friday off to really reflect a little bit on not only what's coming, but really what I've seen over this 25-year period. When I started in Texas, we were in the midst of the Hopwood decision, which was a Fifth Circuit court case around the same issue. So for me, this has now been a full circle professional experience on the same issue, with the same, posing the same challenges, with a lot of still the same unresolved systemic issues that we were talking about when I was a mere 22 years old. From the admissions and enrollment side of this, I think heading into June, and I've worked now with Art for almost all of those 25 years, and so he and I have just been kind of attached at the hip. Can I turn the other one on?
Yep, it's on.
He and I have been kind of attached at the hip around some of these issues for a long time, but I think now that we actually have the decision, as opposed to speculating about the decision, what we're seeing and focused on is both a couple of pieces of reality. One, that selective college admissions is relegated to a very small portion
of institutions in the country, right? Almost 4,000 degree granting and four-year degree granting institutions in the country. Selective institutions are a couple of hundred of those. Most universities, most students get into where they want to go, high admit rates, etc. That's not how this is presented in the public, right? You know, we're presenting as though this affects every institution that's out there, and I think that's one of my biggest takeaways, that we're affecting students and schools and systems and public opinion for a fairly small portion of the higher education public. And I think that's going to get at issues that we'll probably discuss as it really relates to systemic issues associated with inequities and lack of access to higher education, whether at selective institutions or even other institutions that are differently selective. Another piece, and this is really more foreshadowing now that we've seen this for 25 years and we've actually seen SFFA, which is the same organization that brought the lawsuit against Texas where I was involved with Fisher 1 and Fisher 2. This is not the end of the road. This was not a victory that, okay, we're done and we can now move on. We also know that there are other fights that come ahead, that come beyond this. And so as an admission industry and an enrollment industry, it's not only focused on adjusting to the decision of the court today and what the tool that they took away from us and our adaptation to that under current law, it's also thinking about other aspects of our processes that we know are likely to also be, to become after in short order, whether it's financial aid and scholarship programs, recruitment programs, pre-college programs, things of that nature. And so it's work by a lot of us, and I'm thrilled to see some of my colleagues in the room that do this work, of really thinking ahead as to how do we prepare ourselves for continuing to make adjustments to our process when our commitment to this work, our commitment to access, our commitment to breaking down barriers for students and diversifying our institutions remains the same. The tools have changed, our ability to do it and how we do it has been changed by the court, and we now have to continue to adjust, to that new reality.
Thank you, Kendra.
Hello, everybody. It's hard to talk about silver linings on a day that's mostly overcast, especially in LA. But I will say, if there has been a single silver lining that I've seen over the course of the last, what has it been now, 4 or 5 months, it's that this decision, or these decisions, they're really forcing a set of self-assessments that otherwise don't happen in the name of compliance. And in that self-assessment, I'm starting to see much more motivation for some of the overdue systemic changes that we've been waiting for in American higher education. We know that most professionals mean to do good, and yet most professionals take on jobs that are written for them in institutions that have been carried down over years and years, and that those institutions are really biased toward populations who are already privileged, and they disproportionately put up barriers to students who don't have access. And that combination of things, those two sides, are something that admissions never could have touched on its own, that affirmative action certainly couldn't have handled on its own. And so I think the necessary look in the mirror that the self-assessment of these months has required is opening up possibilities for conversation that wouldn't have occurred. This has been on my mind similarly for quite a while, as I've been working for the last 10 or so years with University of California graduate schools, graduate divisions, as well as PhD programs, in helping them think through how they can advance diversity goals in a context where they can't use affirmative action. So many of you know that California public universities have long been subjected to restrictions on the consideration of race via California Proposition 209, but many of them are also really trying to do right. And so my team has been developing a model for holistic admissions, which I may share a little bit more about later, that does keep diversity at the center, that tries to define in diversity within the terms of the law, and which really tries to motivate people who are trying to do what's right. What we see all the time is that people are on the side of wanting to make a better impact on the populations that have been excluded and nevertheless need guidance. There's more and more social science research on these issues every year, but most people, especially in the graduate education world, who are busy professors who are literally experts on other things, don't have time to get to know that research. They don't have time to get to know what it means for their practice. So the research practice partnerships that I've built, most notably the Equity in Graduate Education Consortium, have been organizing faculty for equity and trying to upskill them to carry out admissions in ways that are more aligned with their values than the systems that they've been handed down. One of the things that has been powerful about starting in California is the model that we developed was already pretty robust to these restrictions on affirmative action. And in the last 2 years, we were fortunate to get funding from the Sloan Foundation to scale it up nationally. And in 2024, we'll be doubling in size to 24 universities. And one of the things we've seen with the outcomes is that by taking some real time to do self-reflection, and then slowly adopt new practices as opposed to just mandating something new and expecting that people will go along with it, you can do the cultural work that needs to happen along the way, deconstructing assumptions about who belongs, what merit really means, and whether it's compatible with diversity or at odds with it. And I think if we don't actually take the time to have the data-based conversation, to have the values-based conversation, that any changes that we might make might ultimately turn out to be short-term instead of the foundation for something longer-term and more systemic. So I'll just close with one of the major lessons from this work that we've had organizing for equity and upskilling for equity. It's that it certainly does not stop with admissions. If anything, that's just the starting point. So we've expanded into tracks on mentoring, on well-being, on recruitment. And so I think in the long term, there is going to be an opportunity to really organize ourselves more systematically around research-based practices and evidence-based practices, while we're also continuing to do that work of generating new knowledge. So I'm a proponent of the research practice partnership model. I've seen its impact. I've helped experience the ways that you can grow in this area, and I'm really proud of Rossier's work as an entity that's trying to push this forward.
Thank you, Julie. Hello, everyone. Thank you so much for coming. It's an honor to be on this panel with such great colleagues. Like Kedra, I have been involved in the college admission and enrollment world, where I directed enrollment and admission at the University of Arizona, at the University of North Carolina, Chapel Hill, and here at USC prior to joining the faculty. And so Kedra and I have been colleagues for many years. Art has worked with me and all of us in this world for many years as part of the Access and Diversity Collaborative, which he founded pretty much. And he comes to this with a real well of knowledge, not only of the law, but of these policies and practices that we're talking about. And more recently, I've had the great privilege to work with Julie on the faculty. As you heard, I work in the Center for Enrollment Research, Policy, and Practice, so we study these kinds of things. And I'm going to give you a few things that are a little bit, some from general and specific things that I'd like to share about this. And first is, our mission in the center is to promote equitable enrollment policy and practice. So let's just start from that understanding. And I think it's important to understand that this SFFA versus Harvard and UNC case is part of a piece, and that is a strong agenda against diversity, equity, and inclusion in higher education. It's one of those pieces. It's been a steady, well-funded piece that has now in its third major case at least. And will continue, as Kedra already mentioned. There's also, as you well know, a larger political agenda to attack diversity programming in the United States in general in higher education. So I think it's critical to understand that and to begin to say, it's time to redouble our efforts in all of this, and I heard you just heard something about that. But it's also important to understand that we don't give them a bigger victory than they got, and that we understand what the case was really about and what it prohibited, but also what it left alone and what we still have to use, and that includes our doubling down and our commitment in so many of our other programs that we use. And now we need to, in earnest, seek all race-neutral means. We need to, as I said, double down. We need to be wise about what we do in any of our programs relative to when someone gets a special consideration or a special, benefit. I think that would be a legal term. Art will do this, I'm sure, far more expertly. We, as Julie said, we already had built-in barriers and still have them to access, involvement, and achievement. And we need to do the hard work to defend ourselves as we do this work. And part of that means that we have to align our objectives and our strategies and then our actual tactics, our actual execution to the mission and to those parts of the mission that suggest that we really do have this obligation to provide equitable education to those who we serve. Now, the one thing I'm going to bring up that isn't talked about a lot in all of this, and that is communication. And I think like Julie said, it's hard to look for a silver lining, and I don't know that this is a silver lining, but it's a different perspective. One of the things we know is that we never won in the court of public opinion on the issue of using race as a consideration in college admission. It was always suspect. In fact, look at all the citizen referenda that passed that prohibited this. And so there's a new opportunity, perhaps, to recast our set of arguments. We have a chance to create a new narrative about the criticality of diversity, equity, and inclusion without folks pointing to a practice that they viewed on the face of it to be unfair. At least many people did. And to be fair, honestly, that was, for some who even it benefited, was oddly degrading in some cases. Now, I don't agree with this opinion, but I'm trying to set a stage for a new way of thinking about how we communicate about it. So what is compelling? What's the compelling interest of the nation regarding diversity, equity, and inclusion? Is it economic strength? Is it broad social benefit? Is it political stability and progress? Yeah, it's all that. But how do we take that narrative and say, this is what we're about in higher ed, this is why it's important to us, and how do we win future cases in that? So that's what I'll say before we turn to Art.
Art, it's on you.
Thanks so much. I'm sorry I'm not there in person, particularly because I'd love to take you all to dinner and commiserate over this Kate back and have this rich conversation continue. Let me hit three quick points, if I can, from a legal and policy perspective. And my first one is actually just to explode what I think is a prevalent myth around the case, and one that's being advanced by those on the right who want to take the case, I think, beyond its breaking point. There is a sort of conventional wisdom out there that, as bad as this case was, and by the way, I should say, a really horrible decision. I've already shared this with Jerry in light of my sort of teaching role. If Chief Justice Roberts were a student in my law and enrollment management class at Rossier, he would have gotten a D+ on this opinion. We could spend the balance of time critiquing the opinion. I'm going to try to stay away from that. But I do want to acknowledge the fact that this was not a total wipeout. It was a consequential earthquake. But in the same breath where it said institutions can't consider, for the moment at least, an applicant's racial status, because we don't have this understanding now of what we thought we knew about compelling interest, it also held up the notion that students can and should talk about.
We'll try getting him back.
Okay.
Okay.
All right, we'll come back to Art, hopefully, shortly. But as he was speaking, and you touched on this, Jerry, I was thinking about this. How did affirmative action come to be so controversial? Now, I remember as a college student, the Bakke decision and the protest over that in the 1980s. But before that, it was Democratic and Republican administrations that enacted affirmative action laws. And then around the late 70s, we started to see a backlash. Did anybody want to offer a perspective on what changed that made it so controversial?
I'm glad to say a couple words. I think, Jerry, you're right about the importance of narrative and communication, because when the narrative about what affirmative action was began to shift away from a method of providing a way of recompense for past injustices and shifted toward advantages for some racial categories, it opened up the narrative that it was producing reverse discrimination. And I think that was a turning point. The public narrative was really fundamental in making what had previously been a very targeted, narrow strategy for a targeted, narrow set of institutions, something that the whole population could get divided upon.
But then I'm struck by what Kedra said. This is just a small number of institutions we're talking about. So relatively speaking, a small number of people, but we've seen state referendum here in California, Michigan, and elsewhere. So it's been used, and I'm trying to understand, given the size of who's affected, how did it if you could just explain that for
Well,
us.
I mean, I think when you think about it from the admissions and enrollment standpoint, what we've also had happening over the last 20, 30 years is a extreme selectivity happening in a set of institutions that are highly valued by a portion of the population, whether it's aspirational, whether they ever intended to apply, but they kind of hold them as the gold standard of institutions, and all of a sudden we're in a place where it's 3 and 5 and 7 and 10 and 15% acceptance rates. And so the lack of option, the lack of an opportunity for others, I think, has also kind of fueled that issue as it relates to the use of race and ethnicity in admissions. Specifically, my father was very much a civil rights advocate, and he and I would often argue about the difference between affirmative action policy and the use of race and ethnicity in admissions, trying to help him understand the difference between the two. And his argument to me, and he's looking down right now and telling me, I told you, it doesn't matter. That nuance and difference, kind of to Jerry's point, kind of doesn't matter in the court of public opinion. It's about access, the different kind of access. It's about the scarcity of a resource that's important to a portion of the population, especially one that we've also purported as being the catalyst to the better life, right? These sets of institutions will propel you forward and propel generations forward, but all of a sudden it's becoming much less accessible to more people.
All right. I see Art is back. Art, I hope you hung on to those points you're about to make for us.
Thank you. So let me just, my first point is simply we've got to understand there's actually, as bad as the decision is, there's a nuance to the decision, and there's a lot that it sets the stage for what we can do, and we should take that one to the bank, including, by the way, in the longer term. Remember that SFFA asked this court to expressly overrule 45 years of precedent going all the way back to Bakke, even though it fundamentally eviscerated a lot of that precedent in the practical implications of its decision. It did not take SFFA up on the request that it overruled that precedent. We still have a framework that guided us for 45 years. The question is how we lean in and step into that sort of framework. And then so I would just say in my other sort of quick points on that, I think this is a moment for picking up some themes of my colleagues. This is a moment for leadership, not retrenchment. This is a moment to reflect back on these foundations. Julie talked about this. I will remind us all, we've been touting sort of Bakke and progeny, forever on this front about the value and the importance of diversity. The Bakke decision itself was a loss. It was a civil rights loss in 1978 because the argument had been a full-throated pure societal discrimination claim, which the court rejected. We got the kernel of the educational benefits of diversity, which we then set the stage for significant work and advancement for 4.5 decades. So let's think about this case. Yes, we're all sort of obsessed right now on what we do in the immediate moment. We need to be thinking in the midterm and the long term in terms of a bigger picture strategy here. The last point I will make is I've been doing a lot of reflecting on the work I've been doing with so many colleagues around the country on this set of issues. And one of these sort of ahas I had, and it's such a simple point, but it really hit me in a kind of profound way, is we have got to get very comfortable dealing with a landscape of legal uncertainty and how to navigate it. Because this decision was actually, in technical terms, a limited decision that only talked about admission. It didn't talk about financial aid and scholarships. It didn't talk about data collection. It didn't talk about recruitment and outreach and pathways and pipeline programs. And there are implications in some of those areas that have to be navigated. And we're going to be figuring this out as we go over a course of time, but we are dealing now with effectively a kind of blank slate legally moving forward. And it doesn't mean we don't take steps. It doesn't mean we don't assume risk. I've been in no conversation with an institution where the goal has been articulated as let's go to 0% risk. The question is, what is the rational risk in light of the impact you're trying to achieve? And how do we do that and not paint an unnecessary target on your back? So there's a lot of work to do, but we've got to recognize at this moment, while we've got some very clear precedent on admissions policy and practice, there's a lot we don't know, and we're going to have to get comfortable navigating that zone of uncertainty for a while.
So Art, I want to go back to you, and that's on the topic of socioeconomic diversity. One of the arguments used by the opponents of affirmative action is that stop emphasizing race and focus instead on socioeconomic status. First of all, is that permissible? And second of all, what does that do in terms of overall enrollment patterns if that's the focus we take?
You've done a really good job of sort of capturing a lot of the top line that's coming from a number of organizations and individuals on the right. It's a kind of remarkable top line coming from them. It's as if we haven't been thinking about those issues for years. Kedra, Jerry, and I were talking about that probably, I'm going to out us here, 20 years ago. We're old in this context. So I would say a couple of things. It is absolutely permissible to think through issues like first generation status, country or location within a state, sort of geographic origin, income and wealth foundations, other indications that would go to the context in which an applicant has had opportunity or not to show their talent, to show their skill, to show what their potential is. And all of that can be considered as long as it's authentic and mission aligned. So we should be looking at a multiple array of background factors and experiences, including this set of experience factors that may be tied to race that the Chief Justice has given us express permission to do. It's just important that as we do that we make sure that we're doing it in an authentic and mission-grounded way, and we're not doing the, let me just find the proxy for race, by the way, not a great proxy for race. There is some overlap, but not great identity, and the research will establish that. So I think it's really important to, I think as Julie said so well, we sort of go back to first principles at this moment in time. What is our core mission? How do we actually see and believe diversity, equity, and inclusion can frame and shape our entire array of enrollment and other policies and practices?
So, Jerry, I'd like to pose a question to you because the assumption, it seems, of this decision is that by eliminating race, we eliminate racial bias. But we have a lot of evidence of racial bias throughout society, right? Everything from who gets to go to which school, to healthcare, to employment. So explain for us, if we only focus on race and admissions, how does that start to alter, what else does that do for us as a society? Does it take us further down a path of becoming a more racially just society, or the opposite?
Pedro, I'm going to ask you to rephrase that in a way, because I was heading in one direction, and then your final question tossed me a card.
Well, I'm trying to get at the logic behind the decision, right? The decision is, I'll paraphrase a quote from Roberts, that you get rid of racism by stop focusing on race, right? But we have a lot of evidence that race is still mattering in so many different dimensions. It's measurable. Birth rates, mortality rates, infant mortality rates, we can go on and on. What do we do when we have a group of justices that are saying, let's make race not matter in college admissions?
Yeah. I think a lot of things that we were just talking about. We've got to change our narrative and demonstrate why this really matters and what higher education's all about. We've got to do all the things that Art just mentioned. We've got to make it clear that in fact race is part of what a person brings to the table. Race is a part of who we are. That we can't separate race from who an individual is and from what their experiences are. And there was a little crack in the decision, that allowed us to consider the experiences of a student based upon their race and what they bring to the table. And we've got to use that. I would say That's primarily what I think of when you say this. There's a couple of other points that maybe about how we just have to persist on what we know we're all about and what really matters, and continue to enlighten folks.
Yeah.
But others may have another set of responses.
Well, let me pose to Julie, because you've been working on graduate admissions for a while. Even with affirmative action, they weren't looking so good in a lot of fields. So what, where does the work go now? How do we, and a number of people saying we can take this more holistic view of students, and you suggested that too. Does that seem to offer promise of desegregating some of these departments out there?
Yeah, holistic review is no silver bullet, just like there is no silver bullet for any kind of inequality in this country. But it is superior to methods that rely on metrics that are disproportionately distributed in the population. So some of you may know that Compton Unified School District was part of an alliance that sued the University of California around their use of the SAT because it was producing disparate impact on Black and brown populations who were already underrepresented. And that was part of the University of California's larger decision to eliminate test score requirements, but it was also part of this longer-term process that Sandra Day O'Connor endorsed in 2003 around the use of individualized holistic review. And research with admissions officers tells us that it means different things to different people. It might mean looking at the whole file, it might mean thinking about the whole person, and it might mean looking at the context in which they earned the opportunities or experienced advantages and disadvantages. What the research also tells us is that holistic review that centers on contextualization is more likely to produce outcomes that yield benefits for underrepresented populations, both socioeconomically and in terms of race. As it concerns graduate admissions, it means a lot of things. It means in part those issues around test scores and socio-emotional competencies, but it's also getting professions and fields to think seriously about that mission question. What does it mean to have a more diverse set of doctors? Well, it means lower infant mortality rates. What does it mean to have more diverse physicists? Well, it means much more creative problem solving. And every field kind of needs to have its own conversation about the impact that diversity can make within their field. And that's part of that larger self-assessment process. The great thing about this Roberts loophole is that as universities are starting to figure out why diversity is relevant to their mission, they can begin to seek more systematically what racialized experiences, regardless of your ethnicity, can lead to the contributions in diversity in that area. So the big one that I hear within Rossier is that we have an equity mission. And so in our PhD program, we're pretty serious about asking every applicant, we have an equity mission. How are you prepared or interested in contributing to our mission? And that's one of the personal statement prompts for this year that has been approved, by the way, by our Office of General Counsel. And I think every university is going to need to do its own conversation about the relevance of diversity, equity, and inclusion to their graduate programs. And it's a good task for a society as diverse as ours.
So Kedra, I warned you in advance I was going
You did.
to pose this one. But many people are wondering about legacies and where they fit in to this. And
Ashley, you want to take it?
and I don't know if USC is taking a position on legacy admissions, but what's the thinking now? And you can either speak with your VP hat on, or you could take it off and speak as a citizen.
It's all one big hat, whether the top is open is a different issue. So legacy as a single criteria is agnostic to holistic admission writ large, period. Holistic admission teaches us, if done well, and Julie's laid out quite well, that not all utilization of holistic admission is an equity-centered model. And so as an admission industry and an enrollment industry, right, we all have work to do to make sure that we are truly living out a holistic admissions process in the way that provides those equitable opportunities and experiences to students. Where legacy or the utilization of a student's connection to an institution as a single criteria for making an admission decision does not fit this model. On the other hand, what I would also say, though, is that that just as we've talked about the presumption and utilization of socioeconomic status as the alternative, to understanding the value of race and ethnicity as an educational benefit to diversity, so must we be careful about the presumptions of what legacy means and or of what it means to understand a student's experience, to allow a student space to talk about their experience. We have to we have to understand that privilege goes much further than whether or not legacy is being considered, and we kind of alluded to that in some of this conversation. Every aspect of the admissions process contains the opportunity for bias and for privilege. Letters of recommendation, who writes them, who has access for someone to write them, testing and the disparate impacts, that Julie has referenced, the schools that students attend, and therefore the rigor of classes that they have available to them, the activities that they can participate in. Every aspect of the process depends on a holistic admission system that appropriately takes into account context and the environment and understanding on the individual student level what that opportunity is. One of the things that if I had the opportunity to be full professor as opposed to full-time administrator, I'm really curious about the impact of second generation status. Rossier, for example, has been producing teachers and superintendents and principals for the state of California for decades, creating middle-class opportunities for families that are now second-generation attendees at institutions that also lose their ability, lose that privilege as we think about banning legacy in the process. And I suspect that that's coming. It's coming from higher order than individual school decisions. But I say that because it's nuanced, and it's more than a presumption that legacy equals a rich, wealthy, white female student, from fill in the blank at a certain institution. And instead, we have to focus on making sure that our holistic admission processes are looking at individual students, their contributions, their experiences, their stories that they share, and really trying to remove the bias from all aspects of the process so that we can level the playing field for all students that are here. You may know there was a cartoon that I've referenced all the way back to the Fisher case, and I think it actually goes back further than that. If you Google affirmative action cartoon, it'll come up, and it's a group of students. Each one of them has a label under them: son of donor, legacy, athlete. Now it could be low-income student. It could be top 10% student in Texas, and ultimately there's another student that's pointing at all of those students, saying, "That's why I didn't get in." That is a presumption that we have got to get beyond, and we haven't done it in the full 25 years that I've been in the profession, because it still assumes that scarcity of space is related to someone that is unqualified for the seat that they fill. And that's simply not going to be the case, for those that are appropriately using holistic admission in the process. So my challenge with it is that we can't let it be a straw man. Yep. That if we ban certain parts of the process, whether it be testing, whether it be legacy, et cetera, that all of a sudden the doors open and the systemic issues that affect access for students across the country and coming up through that pipeline are solved, because that's not going to be the case at all. We have to focus on those intrinsic and systemic issues and make sure that our processes across the industry are appropriately applying an equity model that really is looking at, breaking down those barriers, breaking down those processes, better communicating with our public what we're doing. This world is the black box to the 17-year-old and their family. I mean, we're told that all the time. They simply don't understand once they go in what's going to happen when they come out. And it's on us to continue to open up that box and make more sense of it.
Okay. Jerry, were you trying to?
Yeah, I was going to, just add some data to some of this in a suggestion. I think a lot of it gets down to how we begin and how we will continue to define merit and what's meritorious in our midst. And I think Kedra just did a good job of talking about that. But if we just look at even using socioeconomic status as an example, and we talk about trying to define, sort of what privilege looks like and how do we know that these barriers exist. Well, Opportunity Insights is a group of Harvard economists, and they did recent studies, and it shows that a student from a low-income background with the same SAT score as a student from a wealthy family is less than half as likely to get into one of the Ivy Leagues or a selective university. And those from families whose income level are in the bottom 20% are 77 times less likely than their wealthy peers to be admitted to an Ivy League or a selective institution. So, there are clearly barriers. Now, are they legacy? Are they early decision? Are they demonstrated interest? Demonstrated interest, is considered often. Is a student really going to come here? Have they been able to show interest? Well, who's better able to show interest? Who's better able to travel to campus? But then it gets down to me well, then what are we going to do about it? And can we begin to construct alternative criteria? For students from low and low middle income students or minoritized students who fall into these categories. And for example, would we give extra weight to those students who have strong academic backgrounds, leaving aside test scores for a moment, who have strong academic backgrounds, give them an extra boost in college admission? And wouldn't that maybe at least put them on similar footing as those who get a different kind of leg up, in other words, affirmative action for the more wealthy? So these are the kinds of things we really have to start thinking about. And this is where some of the test-free programs that we're hearing about start to come into play, and we start to think about how do we really define merit, absent some of the things we've come to understand really vary by race and by income.
I guess what I would just add to that is
I'll get
that
you in a second, Art. I know he's trying to jump in. No, you
Oh,
go, Julie.
oh.
No, go, Julie. And then
Okay.
we'll get Art back
I'll
in
keep
it.
it short. I would just add that what Estella Ben-Simone's research on equity-mindedness, what my research on admissions shows, and others, is that the criteria about conversation, we could go round and round and round and round. But guess what? Humans are making decisions with the criteria and the information that they have in front of you. And any of you who do admissions, you get this deeply, right? So we need to be thinking as deeply about the how of our evaluations and the how of our decision making as we are about the what of the criteria that go into the algorithm.
And Art, I want to go back to you because where you talked a moment ago, you thought ambiguity was a good thing, but if I was a university president, I might be thinking, I'm opening myself up to potential lawsuits here. And he's shaking his head. What would be your advice to university presidents who want to do the right thing but don't want to be sued? Where's the sweet spot of doing the right thing and avoiding that?
So, welcome to my world. This is the space we are in. And I think, frankly, I used to characterize, Julie, the graduate education as the Wild West. I think all of higher education in the admissions realm right now is the Wild West. The kind of oversight and the litigation that we're seeing pop in every direction. I think the landscape for the foreseeable future is we are going to face litigation risk. I think the fundamental question is, are you doing the right things in the most strategic and effective way you can? And so while litigation risk and what the law says is obviously a driving force in the conversation, this is about getting regrounded in mission. And I think picking up on what both Jerry and Julie have said, part of my plea with organizations that are leading some of this effort, as well as some institutions we're working with, is to look at this case and the decision and its effects, not just the what do I need to go in a myopic way and fix in terms of admissions to comport with the court's opinion. That's important. But that's a quarter of the conversation that needs to be happening right now. We actually need to be elevating the actual entire landscape from that first outreach point to that final financial aid dollar and say, we now have a new legal landscape. It has fundamentally shifted how we think about issues of diversity, equity, and inclusion. That policy that I established on early decision or transfer or legacy status 5 years ago or 5 months ago is now operating in a fundamentally different context. How are we thinking about recalibrating the entire array of policies and practices in a way that I think we appreciate, because when lawyers walk into the room, you immediately see the red light don't do. We are trying to lift up what do we know with confidence that you can do, or what you can do with moderate to limited risk if appropriately designed. And so I think it is not this really sort of mechanical binary decision that's being made. There's a lot more nuance and there's more landscape to elevate, to illustrate where we can invest and what we can do, frankly, with more intentionality around issues of race, where federal non-discrimination law was largely, exclusively untouched by the court's opinion. So I do think it's a landscape that is not, to your point, not without challenge, but it is navigable. And I think what's important is lifting up those policies and practices that really should be front and center for institutions to be rethinking about.
All right, well, thank you for that. So I'd like to open it up now to the audience, both those who are here as well as those online, to pose some questions to our panel, who've been, I think, really illuminating a lot of important issues. And we will need a microphone. Yes.
Thank you, USC, for providing this forum to us and the expertise that we're listening to. When I hear what has been addressed, on the one hand, my conscious mind flows in certain tributaries to coalesce those thoughts so that I can understand it. On the other hand, I see what the Supreme Court has done to demoralize many people who otherwise felt they didn't have a reasonable shot at it anyway. And that's like a cluster bomb. Mm-hmm. That cluster bomb hits everybody. And what we have here are initiatives, insight, skills, and the ability to collaborate with other individuals that will help us develop our mindset so that when we reach out to another person that is not our duplicate, so to speak, we talk to that person as a human being that's capable of doing all that he or she can do in their particular situation. What we do not want to do, and I raise this, and this is going to be shorter, is that we do not want to keep walking. We want to talk to that person that is asking us, what should he or she do? And we may not have the answers, and that's a good thing. But we will not allow the bombs to continue to fall, because this is not what is made up of our society. The Supreme Court has a very small bandwidth that it's manipulating on purpose. So we understand it, so forth and so on. So what we want to do is maintain, as Jim Quick does, his gesturing, that we have a brain, that we're all working together, that we don't care what we look like. We just see that the person is breathing and asking us questions, and if we don't have the answers, we go to somebody that does. So the collaborative, interactive, moral, and expertise is going to bring us to the higher plateau. And I appreciate what we're doing today. Lastly, do you think that John Roberts purposely thought through what the impact of this decision would be, he and Thomas, or do you feel it was just something he had to get out of the way so he could find something else that he really wanted to do? Thank you.
Dave, we want to take it? It sounded like a question for you, Art.
It did.
Everyone's looking at me. It's inconceivable to me, and it's hard for me to even say this, because I do think really, like, even if I agreed with the decision, he'd get a low grade. The design and the analysis of the decision is baffling to me. It's cursory, it's superficial, it's inconsistent. Like, it's all those things that you would give a D- on a paper to. But it's inconceivable to me that he didn't think long and hard about this opinion and its construction, where he's in the same breath saying we have a colorblind constitution, but we should consider individuals' racial experience because, by the way, some of them have been subject to discrimination. And by the way, you can consider their racial experience, not their status. Like, it's mind-boggling in a very fundamental sense when you step back from the details. At the same time, this has been a Chief Justice who telegraphed back in 2007 in a major K through 12 admissions case. I think you teed this up earlier. The way to get rid of race is to eliminate race from consideration. I'm paraphrasing. That fundamentally fails to acknowledge the systemic and structural issues tied to racism that are indisputably present in our country. And so you've got a fundamental disconnect between a Supreme Court that is sitting on high and the reality that I think we are all experiencing if we are willing to acknowledge it. So we've got challenges ahead. The court matters a lot, but I remind people that when you go into those closed door conversations with institutions, the first question is not, what did the court say? The first question is, what is my mission and what am I trying to achieve? And in that context, I'm looking at what the court said.
Thank you. I see a hand back here. And then you'll be next.
Hi. My question is about what should we worry about? Because you've sort of said this isn't you didn't say it wasn't a big deal, but you said it affects a relatively small number of colleges. But it seems like a lot of things might be at risk because of this decision, right? And you alluded to that, but are things already happening because of this decision? For example, I'm a first year in the Rossier Educational Leadership Program, and so we're writing our paper on spaces for students of color at universities, like I'm Native Americans, like the Native American Student Lounge. Are things like that at risk now because of this ruling, even though the ruling does only look at this particular type of admissions? Thanks.
I think, let me be clear. I mean, so the court, has spoken about the use of race and ethnicity in admissions, right? That was the decision that came out in June. What we also know is that there are civil rights OCR complaints, that are affecting institutions writ large. And so my point about selectivity in admissions and kind of that admission space is that that small market has been expanded to encapsulate kind of all of higher education, which is inaccurate. But the risk that you're alluding to are very accurate for any number of institutions and types of programs. I mean, there are current OCR complaints. The Office of Civil Rights has the ability, and they receive a complaint, and they therefore must investigate. Those investigations are already having to do not only with race and ethnicity in whether it's admission processes or pre-college programs or hiring practices or fill in the blank of issues along those issues, but also gender, along gender lines, along any number of the federally protected areas, that those are now starting to be raised at institutions, and so it's a double-headed threat. We're responding to the court decision, and I think we say in our spaces that we need to be careful about not overreacting to the decision itself, but at the same time we have to be very cognizant that there's other elements of grievance around processes related to race and gender, et cetera, that are also mission-driven and mission-specific for institutions that are currently in the system at institutions across the country. And that has nothing to do with selectivity and everything to do with any number of programs. That's not only colleges and universities. We're seeing it in the corporate space. We're seeing it in the K-12 space for selective programs, girls' code programs, special camps, all of those kinds of things. And so that's what I mean, that it's much bigger, even though the headline, has been able to focus on the race and admissions case. The underlying issue is significantly much bigger than that, and it is a very real and relevant threat for any and all types of programs that serve to benefit the marginalized, and as it relates to access to programs, et cetera.
There was a hand here, and then we'll go to. Oh, did you want to respond, Julie?
Yeah, I'll just mention too, there's a sort of second order risk on the horizon right now. There's a case against Thomas Jefferson High School where they have a racially selective
That's
admissions
in Virginia, right?
in Virginia process where they are using race neutral selection in ways that are completely consistent with the law, with an aim of increasing diversity because they don't have very much diversity. And on the table is whether it is allowable to achieve diversity through race-neutral means, or whether it is always a cover for sort of race considerations. Now, if that does end up going to the Supreme Court and being heard by the Supreme Court, the decision that was levied by Roberts could certainly be used to create a great number of additional restrictions and risks, including things like race-neutral holistic review, including things like race-neutral fellowship selection. I think then we are really much more subject to the forces of cumulative advantage in society than we are presently. And so keeping our eye on that will be important in the next year.
Okay. And we'll go here, and then we're going to go online to if there are questions online.
You kind of answered a little bit of my question, and the K-12 started to be mentioned. I work in K-12. My name's Amber Blackwell. I'm a dean of culture for K, the accelerated schools. I don't know if anybody's heard of it. It's like right around the corner. So we have a lot of kids who would love to go to USC. But most schools are segregated at the K-12 level, predominantly by race, which is contributing to inequitable educational experiences, which ultimately contributes to the barriers of admissions in higher ed. So I'm wondering, how do we align at the K-12 level with higher ed's direction? Like, what can we actually be doing at the K-12 level? Because it's micro in the macro, and if we don't do stuff there, it's just gonna make, yes, you see the cycle just keeps on continuing, and I just feel stuck listening to, you know, the decisions being made and the conversations around higher ed, because at that K-12 level, where the real qualitative narrative is more discussed, on the quantitative for the higher ed, that's more the conversations. What can we actually do, feet on the ground?
I'll add a little bit of perspective. I'm not a K-12 expert. I've never taught in the K-12 system, but I think as it relates to higher ed admissions, I mean, some of the areas that when we're partnering with schools or partnering with organizations, you know, that are working with schools, you know, are also trying to identify what are those barriers to access and equitable opportunity in the K-12 system. Who has access to honors classes? You know, who has access to certain teachers? Who has access to gifted and talented programs? You know, things of that nature. And I lived that experience in my little small town of who did and didn't have that experience. Because it's that pipeline development that's also a part of who's coming to us at grade 13, right? And what we're looking at and how we impact that. But we know that in the K-12 educational system, that students are limited and often have barriers that are race-based, socioeconomic based, or segregated schools. I mean, I came from Texas. The top 10% law was built on the premise of segregated school systems in the state of Texas, and therefore a way in which to achieve diversity. So how do we break down those values? What decides that 10th grade student can take the pre-calculus class or not, or how are they tracked or routed, as opposed to being able to pursue, you know, kind of what they want? We, you know, often refer to in many states, you know, that third grade test, you know, where schools are measuring, you know, reading levels to determine prison population, you know, forecasts more than they are college forecasts. That's it. The work exists in both places, you know, that we have to continue to break down that access and those barriers and make sure students have equitable opportunity. That's not what we're seeing currently. You know, we're seeing more division and more separation and segregation than we are seeing a willingness to provide true educational opportunity. On the other side of it, it's the continued need for partnership. And the continued need for, in some cases, even relocalizing. You know, USC is an example of a national, international institution with a commitment to, to our neighborhood and to service. But I think all of us have to think more about what that means for us and how and who we recruit and how we work with our schools to develop, pipeline programs. NAI has been around for a long time. It goes all the way down into 6th and 7th grade. Other institutions have started developing programs like that. But it can't be an either or. It can't be the 100 kids, that are able to do it because they can do that program and their parents have agreed to get them in that program. That's not going to solve, the systemic issues. And so we need that same partnership, on the K-12 side to start breaking down those barriers so that students can reach their potential and achieve within their potential and not have it decided when they're in 3rd grade, kind of what their future looks like.
Okay, let's go online and then we'll get you up here.
There's a couple of questions online. One is, why did an Asian student let himself be a part of this anti-affirmation movement? Are Asian students put in a different category based on the motto minority label?
I can't answer the question as to the question, but certainly if you read the case, or if you kind of understand that that was exactly the issue, that if you were to make admission decisions on certain groups determined metrics, that these are the metrics that should be considered, and if those metrics are considered, then that's going to impact a different population. Then there are those who argue that that's discriminating against a different population that might excel in those particular metrics relative to a holistic measure that takes those metrics in context differently and is looking at kind of educational context and breadth of experience. But I can't quite answer the first.
I can say just a little bit more about the second part too. I think there's a long history of efforts to use Asian Americans as a wedge population among communities of color nationally. We see it in California, we see it nationally. And so this was a strategic move to engage with a group of mostly Asian American students as part of this lawsuit.
Okay, great. And the second question is, do the panelists have thoughts on the military carve-out in the decision where military academies are exempt from the ban on considering race in admissions? Why does the court see this group as so different, and will this carve-out stand?
Yeah, I'd like to speak to this if it's okay. And
Sure,
I'm hoping,
Art in too.
yeah, I'm hoping to write with Pedro about it actually. So the military academies have done something really smart since 2003. They've delivered a consistent and strong and specific message about the value of diversity in the academies. They talk about how you cannot have a legitimate officer corps without diversity at that level, because then you have a predominantly black and brown group of soldiers on the ground and a predominantly white. And guess what you get? You get mutiny. Right?
Vietnam.
You get Vietnam, exactly. Higher education institutions writ large have not been that smart. They have not been that consistent. They have not been that specific. They've been all over the place. We've been all over the place. So whether that military carve-out will stand is a different question. But I give them props for knowing exactly what their message is and being able to be clear and compelling about it.
And let's get Art. Art, you want to comment on the military academies?
Yeah, let me just build on that and say agree totally with that. And just to illustrate, part of the reason you've got this, what I think is actually a bizarre carve-out, because the very interests the military are elevating are the same interests we've been talking about amongst all the fields and the professions in higher education for 45 years. They simply had a more specific, concrete, and frankly intuitive case to make to Julie's point. But just to elevate the why behind the footnote, the Solicitor General, who is the lawyer that argues on behalf of the United States before the Supreme Court, argued in favor of Harvard and UNC, but took the tack to try to preserve, I think, the entirety of the compelling interest that the court had recognized for 45 years that it ultimately eviscerated, by simply emphasizing the military case, because it was among the more compelling and intuitive cases. And by the way, she was remarkable. Go read the transcript. She was great. Kind of just amazing oral argument. And I think it just caused a pause for the justices saying, gee whiz, we really don't know about this. This wasn't litigated in this case. Let's create the carve-out. My question is, then what about, and some of the questions and points that have been made earlier have already elevated this, what about the data on health disparities by race? What is the kind of case that a medical school could make distinct from the kind of case that Harvard or UNC made that actually would be robustly compelling and supports the race as consideration in admission? So I actually think it is a potential open door, not only for the case the military might make. By the way, SFFA has now sued the Naval Academy and the Academy at West Point. So we've got more litigation to come on that front, but that conceptually opens the door to other different kinds of compelling interests where I think we need to be focused for the longer term.
I was merely going to make that last point, that the folks behind the SFFA case are now going after the military. On the other hand, we can learn from what the military has done, from what the Solicitor General said about that, and about how we can maybe rebuild a case and maybe try to relitigate some of this.
Okay. Right here.
Hi, I just want to sincerely thank all of you for the work that you've done for this cause. I'm sure it's been very difficult and you've been doing it for so long, and I really appreciate it and what it's done for my generation. My question is specific to USC and our Trojan transfer program. I don't know if it's like put in writing, it probably isn't, but it's known among students to be like preferential to legacies. Do you think that this could work against diversity at USC, and do you think it's going to be challenged, or do you think it is something that can be positive in the long run?
Sounds like you could.
Yeah. I mean, the answer is the perception of what it is not the reality of what the Trojan Transfer Program is. The Trojan Transfer Program is open to a wide breadth of students. There's a historical legacy, that exists there, and there's certainly a perception that says that it's only for legacy or alumni-related students, but not at all. USC, among private institutions, leads in our transfer space. We enroll about 1,400 to 1,500 transfer students a year. It's the most diverse population that we enroll at the institution. Many of those students have come through TTP, which is open to low socioeconomic students, to partnership programs, to NAI programs, and beyond. So there's a perception problem there in terms of what TTP is and a legacy history that exists around it that's not consistent with current practice.
Yeah, super quick. I mean, Southern California is not Boston. And so the population of legacies here is not the population of Harvard's legacies. So I think that difference between what the data would tell us and what the perception is super important to disentangle.
Hi, thank you all again for this panel. My name is Greg Russier, possibly 2012. I loved your question. Is it working? There we go. About the broader impact about this conversation, not just in affirmative action and admissions, but how it affects both K through 12. And my question's about the other side. I run our campus recruiting program for Ares. We're a private equity firm. And to your point, Kendra, we specifically target certain institutions that are ingrained with our DEI strategies to help really impact corporate recruiting. So have any of you thought about or have thoughts about engaging this conversation about admissions with the private sector?
I think about it from a research standpoint. There was a really amazing study by Lauren Rivera that looked at the hiring preferences of financial firms, and it basically found everything that's wrong with selective college admissions as well. So the preferences that go into the selection for those positions really reflect the similar, I'm going to call it opportunity structure that we see here. So yes, I think there aren't enough formal collaborations to talk about dismantling that and at least interrogating it, but they're definitely necessary.
I'll just add very briefly that, I mean, where some of that work is occurring is where we have formal partnerships, because as part of this decision, we're just as liable for partnership organizations, that institutions work with, as we are for our own institutional staff and issues that are internal. Now, that's going to be different when you think about graduate schools and graduate programs and partnership to fellowship programs and things of that nature. So certainly those conversations have started, because where there are partnerships with organizations that are racially that have policies on race specificity, we're having to have conversations about, one, an ability to maintain that partnership if that preference exists, but more so to also help guide developing new policies that are legally compliant.
Yes, sir.
Hi. I'm wondering what we can do to better recruit diverse talent. I'm the co-president of a student organization at Price, and we pair current student mentors with prospective students who are students of color and first-generation students in order to increase diversity and accessibility at Price. But there's definitely a lack of belonging. There's a sense of, I wouldn't get into USC and I wouldn't want to go to a predominantly white institution anyway. So how can we change that narrative and create a better sense of diverse belonging here at USC so that students want to be a part of our community?
Sound like you, Kat.
Well, I mean, I'll add just a first, kind of an observation. I mean, it's related to your great question, and this is, kind of an issue that we battle every year. Perception is part of the problem, and that can be USC specific, but let's talk about selective higher ed and these types of institutions where, again, that scarcity and for some institutions, relative low numbers of diversity across all types does not create the kind of environment that that students will run towards. Part of the work is about expanding the applicant pool. I mean, we just at a very tactical level, we know that our best opportunity to admit and enroll a diverse class is to expand the applicant pool. And for some institutions, we have been all over the country and world, making sure that we have the applicants for that purpose, not for selectivity rates, but to make sure that we have breadth and depth in the applicant pool. For some institutions, that's where their new commitment will be, right, to expand opportunity for staff and others to actually get out and recruit, a broader applicant pool. Part of that also is on the experience that students have on campus, right, and that's continued work that every institution that I, have ever worked with and colleagues that I work with, that's also a focus of the work, because the experience that students have beget an opportunity for the folklore and the reputational impacts, of the past to also be reduced. So we have to not only bring in new students, but we have to have good experiences for those students when they're with us, because otherwise it's counterproductive, to the work. We're battling at the same time public perception and public issues and legacy issues, and things that shape, that shape people's interpretation, of what that experience will be. So it's all of those things and probably plenty that I didn't say, but this work is not new. I mean, and I will say that, this is a new case in 2023, but we can go back to 2014, 16, and 17, back to 2003 and 4, back to Hopwood, back to Bakke, et cetera. So there's been a culmination of work around this space in higher education to broaden admissibility. The number of schools that now do holistic review compared to how many did holistic review 10 years ago has exponentially shifted, even for less selective schools, but recognizing the value of a process not only contingent on test score and GPA or class rank, but really trying to kind of shape and provide a different opportunity. That's what
Can I just add?
Jerry?
Yeah. I just want to say I agree. It's not new, but this case adds an exclamation point to what we have to be doing. We have to be there. We have to be in the students' presence. They have to be able to trust us, And like the College Advising Corps, our Osmanian is here. It is in over 40 schools in LA and 8 districts. Working to do college advising. You heard about NAI. Kedra's team does work in outreach and recruitment. We have to do more and more and more and deputize the students, and we have to get ourselves around this, and we have to support and grow these programs. Yeah. It has to be an institutional commitment to do that. It hasn't been easy to get that commitment over time. It's been frankly easier to do it at USC than in my past institutions, to be honest with you. There was more of a history of committing to the communities, but we have to redouble and keep going.
We're going to make these the last two. This one here, this one, and then one more online, and then that's it.
Thank you. I'll try to be very, very short. Just a statement about the fact that here we are in 2023, and we are still dealing with a legal framework that does not incorporate the experiences or the voice of underrepresented groups. This case in particular had no voice or pathway for a voice for Black and brown people, but yet we let that case determine impact for Black and brown people in particular with regard to enrollment and admissions. The other thing that I'd like to say, and let's just park that over in the conversation about affirmative action, but the legacy conversation, we need to learn how to be able to handle the nuances of really where we're going, because Black alumni, Latino alumni do matter, should matter more, because when you don't allow their experiences or the fact that they are alumni in institutions where they've not been able to take advantage of legacy and the community that brings them, well, then you're dismantling their ability to build community momentum and generational advantage. And so, these are the kinds of things that we get to when we're able to be able to handle the nuances that do come with this conversation. And we're dealing with way too many stereotypes that do not fit the way that race is moving and identity is moving in this country. So,
Thank you. Sounds like a statement, more, but appreciate it. Last comment in the back.
Hi. So my question gets a little specific. So and maybe for art in particular, with Indigenous students who do hold, say, tribal status, compared to that being not necessarily tied to race, but not a racial category per se, how does the law kind of interact with a student's tribal status?
That's a really good question. I've actually been spending about a quarter of my time on that set of issues in the last several weeks. I will say, just to sort of simplify what is a complex set of legal principles, I don't think we've got really good clarity from existing case law. There is a body of case law that deals with tribal status and considers it a political designation, not a racial designation. So you're not subject to the tough rules that we're subject to in the cases like SFFA. Those have tended to be associated with some congressional activity, and it's been linked to sort of the need for some federal recognition or some federal action emblematic of congressional intent. I actually think those cases, the more I've looked at them, don't begin to answer the question. I actually think the simple question is it race conscious or is it race neutral? And we know where the law is on race consciousness right now, given what SFA did. What I would argue is that we've got a valid basis for thinking about tribal status. If you are federally, maybe even state recognized tribe, that some tribes that don't have the federal recognition, to think about that in the context of the way states have thought about geographical difference, or even Ken wrote the top 10% plan in Texas. You're trying to reach all students from all backgrounds. If you can actually associate the question of tribal status toward what you can get uniquely from that experience, not intrinsically tied, although there is the obvious overlap with the fact that a student may be Native American, then I think you've got a distinction to be made, and maybe an argument that this is actually legitimately, independently a political frame, not a racial frame, and there is a foundation for continuing that emphasis moving forward. I will say it is complicated, and it is, if we go back to my point, let's get comfortable with uncertainty in the law. We don't have clear items from the courts, and so it's going to be one space we are navigating.
Okay. I've been told there's one last question. Is that right, Australia?
I probably don't fit the mood of the rest of the folks at the meeting. I came here with an expectation, and I was looking for phrases. And one of them is the family, the Trojan family. I have 3 degrees from USC. I have 4 generations of my family from USC. I worked down the street for 34 years at LA Trade Tech. It's the most diverse place you could ever imagine in the world. And I wrote many recommendation letters. And the reason I came here today is a young lady that was trying to help. And she is talented. She has 4.6 grade average from probably one of the top high schools in Southern California. She has community service 2 pages long. She has everything you can imagine. She applied for admission, and I spent hours writing a letter for her because I care for her so much. She got rejected, and then she got a letter putting her on a wait list, and she got rejected again. 5 generations of her family have gone to USC. I believe in USC. I believe the problems that we have, we're capable of creating a better program for admission than anyone. But I don't think we're there. And her family was hysterical. They didn't know what to do about it. My own son went through community college, wanted to go to film school, and he came down here for orientation, and he got the President's Scholarship for USC Film, which I thought was the epitome of anything he could want. And very surprisingly, he declined his admission and he went to UCLA, graduated #1 in his class. But I'm here to say that I believe in my university intently, and I believe in the education department intently, and I hope that some attention is given to solving the problems internally with a whole lot of intelligent people working on it. I just have a lot of confidence in USC, and I think this is a time of opportunity, a time when you can make changes. And so what I came here to do is encourage you to think about that for USC's sake. And I think that there's so much being lost by not having policies that don't create, those two families are now UCLA fans. No USC person likes a UCLA fan. So I guess that's what I have to say.
All right, fight on. So I don't know if any panelists, before we go, anybody would like to say any closing remarks? Art?
Just thank you for the opportunity, and I just would remind everyone that you know, we've pulled out of challenging times before. This is an opportunity to galvanize, to work together, and to get creative. Higher education is at its best when it innovates, and we're in a moment that's calling for innovation.
Jerry?
Yeah, I'd just like to mention that a lot of you are students or former students or alums, and a lot of you are entering you know, the really critical part of your careers, and you're leaders in your own right. And as leaders, this stuff's going to be on the agenda for you and needs to be on the agenda for you. It's been a long, hard fight, and there's been a lot of people well educated to do the work, and you're part of that legacy, and you're part of that mission. And please keep the faith with the mission.
Julie?
Yeah, I'll just share that this summer I had the opportunity to be a part of the White House Summit on Educational Opportunity. That was part of their response to this decision. And one of the major takeaways from the day is that we're going to need a response nationally that is not unlike our response to the COVID pandemic, where it wasn't enough to wear masks, it wasn't enough to develop vaccines, it wasn't enough to shut things down for a couple of weeks. It was going to take a multifaceted societal response. And so similarly, I would say that we all have a sphere of influence in our day-to-day lives, in our professions, and this is definitely a moment to think about how each of us can be using that sphere of influence we have to create something that is multifaceted, the way that we got through the pandemic.
Yeah, and I think, I mean, I'll just add that I think it's, you know, those of us that do admissions enrollment work, we don't do it because we like having conversations with 90% of our applicants that get denied, you know, at the end of the process. We do it because we care about our institutions, and we care about students, and we care about access for students to the educational opportunities that the institutions we've chosen to be a part of, and to the field writ large, because we work not only for our institutions, but my field in particular, we work well with each other. We learn from each other, with each other, to evolve our process. I'm in a different admissions process than I was in 1998 when I began this work, and so we continue to develop this work and the way that we go about it. And you know, Julie used the phrase that I am very much married to, that it's the intersection, I think we have one word that's different, of practice, research, and I say policy. It could also, you had a different P, I think. Partnership. So maybe it's three Ps. But the intersection of that work to let research inform our practice and inform our policy, to let practice inform our research and our policy, because the boots on the ground matter as well, because you're seeing that real-time impact of the work that's happening in the research spaces. But this will continue to evolve, you know, throughout my career, and I think, Jerry, you said it well, for those of you that are coming up behind us in our classes and going through our programs, to continue to solve these ever-present problems. And so we're all in this together.
Yep.
So let's thank our panelists. I forgot to mention earlier, all of them teach in Ross here. So if you're a prospective student, you get to take advantage of such a knowledgeable group of faculty. So thank you. The work continues, and we appreciate you coming out. There's food and refreshments downstairs.
Thank you.
Thank you all.